The Chief Judge of Rivers State, Justice Simeon Amadi, has refused to constitute a judicial panel to investigate Governor Siminalayi Fubara and his deputy over allegations of gross misconduct, a request that was made by the State House of Assembly. In a letter to the Speaker, Justice Amadi cited existing court orders restraining him from receiving or acting on any impeachment-related requests, saying that the judiciary must respect the rule of law and subsisting court orders, even as political tensions escalate.
The move comes amid heightened political friction in the oil-rich state, where lawmakers have accused the governor of misconduct, including alleged budgetary impropriety and failure to present key financial documents. The refusal set up the panel adds a new legal twist to the standoff between the executive and legislative arms of government in Rivers State, raising questions about constitutional process, separation of powers, and the future of the impeachment effort. Well, to help us unpack the implications of this development is legal practitioner Tohwo Oseruvwoja, who joins us live via video conferencing. Good morning and welcome to Breakfast Central.
Good morning, gentlemen and ladies.
Good morning.
And ladies, sorry.
All right. It's a different twist this morning. The Chief Judge has cited existing court orders as a reason for refusing to constitute the panel. I think the first question would be, what kind of legal or constitutional restraints might prevent a Chief Judge from acting on the Assembly's requests?
Okay, if you look at the Constitution provides for what we call the separation of power. And if you look at the judicial arm of government, it was clearly stated in Section 6 of the Constitution of the Federal Republic of Nigeria, which established the judicial arm of government. And in doing so, the judicial arm of government is the centerpiece for maintaining law and order and maintaining simple coexistence between all arms of government and the citizen also. So if you look at the Constitution and if you look at the procedures being taken by the Rivers State House of Assembly, you can, in the area of the Constitution, is Section 188 of the Constitution. And if you look what critics are saying, what is bringing this controversy is Section 188, subsection 10 of the Constitution, which clearly stated that the proceedings of the panel that will be set up by the Chief Judge, or the proceedings or the determination of the House of Assembly regarding the impeachment proceeding should not be entertained by the court. And if you see what is going on now, a court has restrained the Chief Judge for setting up the panel. And what will be the mind of the people? You know, the law is very unique in the sense that you don't look at it from the English perspective, though we read it in English, but there are intentions to that particular provision of the law. The recent case I want to look at is the case of the Kogi State House of Assembly and Ashebe, where the Court of Appeal said, when the Court of Appeal said that, yes, that provision of Section 188, subsection 10, stops the court for interfering with the proceedings, but when the proceedings goes contrary to the laid down steps that ought to be taken, the court will stop that illegality. So the current provision now is the case is lis pendis, and the Chief Judge, who is the #1 judicial officer of Rivers State, cannot be caught in between to disobey or disregard a pending order of the court, stopping him from constituting that panel.
Now, Tohwo, what's the interpretation of this? Is there a timeline? What happens to the impeachment process against the governor?
Okay, there's different school of thought when it comes to the timeline of an ex parte order. Some will say generally the timeline for an ex parte order is 7 days, while it's renewable pending when the substantive or the interlocutory application is heard. But another thing again, if you look at the recent pronouncement of the Supreme Court, I think I want to mention one, the case of Fidelity Bank and Sancom Consent Nigeria Limited is a 2025 Supreme Court pronouncement when it said every order of court must be obeyed until it's set aside by a court of competent jurisdiction. So as it is now, until either on appeal that ex parte is set aside, or until either the court who granted that ex parte by a motion or by itself set aside that particular ex parte order, the chief judge hands is tied to proceed. So as it is now, is a stale proceedings pending when that order is set aside.
Okay, so if I hear you correctly, the next step will be to set aside the order before they can then, the chief judge can go ahead to set up a judicial panel of, to investigate these allegations. Is that correct?
Yes, that is perfectly correct. Because if you do not go through that means, if that is not done, the court will be caught in between a contempt of the court. And you know what it means when you are being caught by your own rules. So it's something that is not good within the public domain and in our judicial system.
All right. So what will be the next step beyond the setting aside? What are the necessary moves that need to be made for an impeachment order to be seen as valid against the governor? What will need to be in place? I know you've mentioned the order being set aside, but what will need to happen?
Okay, first of all, the Constitution, Section 188 of the Constitution, though the governors of the Federal Republic of Nigeria are vulnerable by the not express determination of what we call gross misconduct, it's laid down 8 steps that ought to be followed. And one of the steps is that a written petition will be received by the State House of Assembly, either by a member of the state, through a member of the State House of Assembly. And when such a petition is received, that petition is not debated whether or not the petition is right or wrong. What the Speaker ought to do is to determine by whether the petition can proceed by just 1/3 of the members of the State House of Assembly. And when that is decided, the governor now forwarded such a petition to the governor. The Speaker now forwards such a petition. That is the first step. The second step is that the governor now forwards such a petition to the governor to respond within a stipulated time, 7 days, within 7 days. Then within 14 days of receiving that said petition, then the governor has the obligation to either respond or either by himself or through a legal practitioner, or decide to keep quiet over the petition. Then within 14 days, where that petition was initially submitted to the State House of Assembly, which is the 3rd stage they are in now, the Speaker will now, by virtue of forward such a petition to the Chief Judge, for him to constitute a panel upon which to investigate the said allegation. And that panel will sit. They have 3 months line to sit to determine if the allegation contains in the petition are true or not. And that can be the governor himself or the deputy governor in the case of Rivers State. And both of them can either represent themselves in person through a legal practitioner to determine defend themselves. Then after that, the panel now will now find, the findings of the panel will determine if the State House of Assembly we proceed with the impeachment proceedings. And what would that be? If they find that the allegations in that petition is not proved, then the proceedings terminate at that particular point in time. But if they find out that, the allegations in that petition is proven, if the thing now goes back to the State House of Assembly for them to vote. They don't deliberate on it, they will vote. And when the State House of Assembly, if that report is adopted by 2/3 of the members of the State House of Assembly, then the determination of the State House of Assembly is to either state that the governor or the deputy governor is impeached. So if you look at all these said points, you understand which need to be followed. Well, the Constitution says that the process do not need to be interrupted, but when these steps laid down are in one way or the other is breached, like I stated earlier, we are not privy to the processes filed by the State House of Assembly, by the governor or deputy governor. And even if we are privy, we cannot determine the merit or demerit of the case because it becomes a prejudice to discuss a matter before the court. So these are the things laid down by the Constitution. It's a straightforward process, is a vulnerable process for the governor, and also it can be vulnerable on the side of the initiators if this process are not followed keenly and without interference and myopic sentiment.
All right, Mr. Tohwo, I mean, you're known to look at it from the legal aspect, and I'm also aware that you're equally a political and public affairs analyst. So I'd like us to leave that legal vehicle and jump into the political vehicle right now. Many have highlighted the issues that's got to do with this, pointing fingers, of course, obviously, to the rift between the FCT minister and the governor of Rivers State. What do you think this latest development will do, especially to the move the FCT minister had made a few weeks back, where he had gone to different communities, galvanizing support and pulling his weight, and also making strong statements such as that he is one who is not to be played with? With this development, what do you think it will do to his moves?
Okay, but let me look at it from the political perspective. I've followed, I've participated in directly or indirectly in Nigerian politics to some extent, and I've also looked at the non-interrupted democracy in Nigeria since 1999. And most times, people say, oh, you look at old novels, you refer to him in old novels and all those stuff. Yes, I said yes, because at the point he is now, I believe we can stop reading when he became the local government chairman of where he started his political career. So the most valuable and most interesting story that can portray his fate or perceived to portray his fate is The Things Fall Apart, when he graduated from university in 2007. That is one of the valuable novels, because I remember that is one of the valuable novels he would have studied as a lawyer or preparing to be a lawyer. Is the fact that what happened to Shewe Ashebe, what happens to Okonkwo, Wike is throwing that part politically. And I want him to understand that there is what we call characteristics within the zones, geopolitical zones in Nigeria. What is accommodated in the Southwest, whereby elders, younger ones respect the elders, they are not bold, they are scared to look at the face of the elders, they only keep grudges and stalk by the side, cannot happen in the South-South. Average South-South man, politically and naturally, are rational and reactive to when they perceive their power are being threatened. I'll give him a good example. Look at the former governor of Delta State, James Ibori, who was the political pillar. But as time goes on, because of the nature of the people of the South-South, you could see that wins has been crippled somehow compared to what is happening in Lagos State. So if Wike believes that what is perceived to happen in Lagos State can happen in Rivers State, he should look at Odili, he should look at Amechi. They are more intellectual when it comes to issue of managing political crisis, but his own will go down the drain with the way things are going. And I believe Tinubu, who is a very smart politician, looks at the purpose of the outcome, not emotional intelligence that Wike is going alongside. So that's just what I think is going to happen in Rivers State.
All right, I'll still come back to, since we've delved into the political vehicle, I'll come back to that, but I want to lean back again into the legal vehicle. Should this matter, I mean, if it feels like you've said, they would have to, first of all, set aside the order, order before they're able to proceed. But it looks like it might end up becoming a battle of court judgments. What will that look like, especially bearing in mind that there is the immunity clause that protects the governor, at least while he's still in power, from being taken to court?
No, the immunity clause that protects the governor, if you look at it, the exception to that is that provision of section 188. Remember, they didn't take him to court, he took them to court. But a governor can also be taken to court when the issue in question comes within the constitutional provisions of his responsibility. So the bone of contention now is there is a constitutional breach. Do you understand? And who is the party to the suit is the governor. So it's the office of the governor as a person that they are taking. And when that office is questioned as to the holder, then this provision of the immunity covers does not imply in this regard.
Okay, thank you very much.
I wanted to know, I mean, still on the legal part, if there are alternative dispute resolution mechanisms and the people of Rivers State, I mean, the stakeholders find a way to manage a crisis. Is it possible for this impeachment process to be reversed legally? Or
no,
Yeah.
Okay, if you look at alternative dispute resolution, that is no longer a legal aspect. It has to fall under the political aspect of the issue. Yes, the elders of the party may likely intervene or will want to intervene in this particular situation. But the question with at what cost? That is what the question should be. But legally, two things will happen. Is either the court quash the process and the process starts ab initio, because the court cannot stop the State House of Assembly from not discharging their responsibility. But if they said they will resolve it legally, which some of us were a bit concerned through alternative dispute resolution, you will now see at what cost, where a man, and with all due respect to the Speaker of the State House of Assembly, Rivers State House of Assembly, where posterity will not judge Wiki clearly on what is going on in Rivers State. Posterity will judge Fubara and the leader of the State House of Assembly. That is who prosperity, because at the tail end of it, who can be perceived to have the mechanism of governance in the state. So Wike is in his own destiny. Let me use it, basically political exile, being a FCT minister. You as the Speaker of the Rivers State House of Assembly, your step actions and inactions will determine what the future holds for him and Fubara.
All right, and also still looking at it from the legal perspective, would you say that this refusal by the judge, the chief judge, to set up the judicial panel against the governor, do you think that this will set a precedent for governors in the future to be able to stall or delay impeachment processes?
Well, there is already a precedent for that. Like if you see the authority cited by the chief judge of Rivers State, yes, there's a precedent for that. If you see the authority I cited that emanated from when the then deputy governor of Kogi State was being removed, there's a precedent for that. The only thing is what we should be worried about is the consistency of the judicial precedent and the view as to the rule of law. That is what we should be worried about. Yeah, for precedent, yes, it has been there, and we've seen precedent whereby the process went through, but the court turned it over. I think Edo State Deputy Governor example is still part of it. Then the Kogi own, we talk about so many state governors, even Peter Obi. Those are precedents that has already been in place. So the only thing we should be worried about is the consistency and the independence of the judiciary for them not to be used as a tool to clog of the other arms of government when the process are clear, when the process is unambiguous, and when the process are clearly followed. That is what we should be worried about.
Now, finally, just before my last question, I mean, there's been talks and conversations about the judiciary drawn too deeply into political matters and inundated with cases of politics and also elections. It's a responsibility of INEC, for example, to conduct and announce results of elections, but oftentimes we see that it's the courts that finally pronounce these winners. Are there any, what are the implications for the Nigerian judiciary? And has it got into a crisis level?
No, well, if you look at it, you discover that you should also understand the role of the judiciary when it comes to issue of the law. The role of the judiciary involves interpretation of the law, the intent of the legislature. That is the intent of the law. That is why I said when you look at the law, you read it in the plain English language. But if you look at it, the role of the judiciary is to achieve the intent of the law. So one, you should know Rivers State is one of the states that shapes our political landscape, our legal and political landscape when it comes to electionary, when it comes to issue of the will of the people. You know how Amechi became the governor of Rivers State. You could see the interpretation, though that was corrected by the National House of Assembly, when they amended the Electoral Act. Then when you now look at it from the other perspective of the fact that the judiciary is bedeviling in political crisis and other stuff, we also give them some kudos when it comes to some bold and courageous pronouncements to stop excesses of executive to stop excesses of politicians. It's just that the political will for the executive to implement them. You see the pronouncement of the State House of Assembly, of the Supreme Court, when it comes to the issue of local government funds in Nigeria. So these are things that we all need to look at. Then if you look at electioneering process, it's a complex issue. I will tell you, it's a complex issue. And most times when we criticize the judiciary, we should also go back and look at the effort of lawyers when the effort of lawyers in presenting this case in question. I've been privileged to join election petition matters. I've seen the level of negligence put or negligence work or work put in by defense or prosecuting lawyers. And at the end of it, they come to the media and start shouting foul play, making the media public opinion. We should also know that our judiciary are barred. They may be in the society, but they are barred to see us comment on issue of the society, except things brought before them. So they may know what, or they may perceive to have seen what happens, but is what the judge, is what the court and the lawyers put before them they look at. So that is one thing. I've seen a situation whereby a judge said, well, my hands are tied because the evidence before me, the party has canvassed their case that I could not but agree with them. And that is why we have several hierarchies of the case. If one of the judges are biased, do you understand? The other 3 wise men or 5 wise men may not be biased. Then the 7 wise men, which is the apex of them all, will not be biased. So we should also look towards professional negligence when we look at these public interest cases. We should look at the document file. We should look at the process. We should look at the way the lawyers handle the case. So that is it, because I believe as a lawyer, I believe every judge look at the loopholes. If the judge wants to compromise, it's based on the loopholes created in the process. Then lastly, let me make it clear, because you are journalists, I should know one thing. Election petitions are won at the beginning of the electoral process. So not when you have agents who collect documents. It's not when they announce results, you start collating information. So, and you start coming to public domain, shouting and every other stuff. So at that point in time, your agent determines your level of the judicial proceedings. Then you cannot blame the judge when they see that politicians have taken advantage of English stated language of the law, and you would say they should not make pronouncement on the intent of the law.
Just like the case of 2023 and Abuja, the and, says is a state. Abuja has been, I mean, that whole drama that took place in 2023 and all that. But that's true.
You don't No. The other thing, let's look at it like I stated earlier, the intent of the law. Yeah. Let me come back to you. Let's assume that you contested in your union in New Central as a unionist. Then because they said you must win two members of each of the departments to become the chairman of the union in New Central. Then you have 10 departments. Do you understand? And you won 9. Two members in 9 of the departments. Then you just want only 1 member in 1 department. And you are saying that the law is fair. Or for them to say, oh, because you didn't win 2 in the other 10th department, it should be fair in that regard. No, that is why I said the Supreme Court or the court in its infinite mercy and wisdom look at the intent. The intent of the law is not to deprive, is not unjust. So in most cases, that and of that FCT we are talking about, and the cases they were referring to, and in that particular case was not the subject matter of the litigation, that it's just a bypass statement. And if the Supreme Court is faced with that particular provision, they ought to be fair, in my own personal opinion, to say, oh, we cannot deprive the generality of majority to a particular state. Thank you.
All right, Mr. Tohwo, thank you so much for speaking with us.
You're welcome.
Thank you. I mean, you've broken it down. I'm sure our viewers have been able to get the points. Let's see what will happen next, because the countdown is on. We do hear that Mr. President has spoken, I mean, through his special advisor, that he has, the River State Governor has his full support. So Thank you so much for joining us to also shed more light on this. Thank you.
You're welcome.